thank the honourable member for Watson, and I call the honourable member for Goldstein.
Well, thank you, Deputy Speaker. And Deputy Speaker, it's an old saying that you don't want to get between premiers and a bag of money or a pot of money. Well, when it comes to the Labor Party, you never want to get between them and workers and their remuneration, because they will make sure at every point they do everything they can to deny them a pathway to secure a job on their terms, on their conditions, because what they want is to dictate to them their terms and their conditions. This motion is not about empowering workers. It is not about empowering the opportunity for Australians to choose the terms and conditions of their employment. It is about the power of the unions. The power of the unions to dictate and decide how people work, on what terms, on what circumstances, because they are the benefactors of the Australian Labor Party's largesse. They use the power they have in this chamber to benefit the few rather than to empower Australians to make their own choices and make their own decisions about how they wish to live their lives. Now, Deputy Speaker, if you believe the members of the opposition, they'll lead you to believe that labour hire is this incredible sector which employs millions of Australians and seeks to undermine workers across the board. The reality, it is nothing like that. Labour hire is a discrete sector of employment arrangements which has been stable around 2% of workers over the last decade. But what it critically does, Deputy Speaker, is provides a pathway for some people to secure employment on their terms and their circumstances. I have labour hire companies that operate out of the wonderful electorate of Goldstein and work to actually provide pathways for people to secure employment and jobs, again, on their circumstances and on their terms, and on terms that suits them, not union bosses. And of course, we know that labour hire employees have exactly the same rights and protections as other employees when it comes to issues like unfair dismissal rights, award entitlements, general protections, and of course, workplace health and safety protections. But what we make sure is that when people secure employment on their terms and in their circumstances, what you actually do is empower people to be able to secure employment who may not otherwise be able to find it. You provide a pathway where, for instance, women who may have particular circumstances to do with their family arrangements or, of course, their responsibilities to others to secure employment on their terms and in their circumstances so they can stand on their own 2 feet. The same is true in any family arrangement where I know many people who may choose, because of a casualised nature to other issues they face in their lives, may not want the rigidity of a 9-to-5 job or on terms that suit law but suit them. And that is ultimately the focus of what this government is seeking to do. It's to make sure that we provide pathways for everybody, every Australian who wants to get a job, to be able to get a job, to have a go, to get a go. But of course, Labor wants to stand right in the middle of any pathway that enables people to freely choose their terms and their circumstances of their employment. Now, of course, this is the direct consequence in part of a significant decision made by the courts. And we have introduced a new statutory definition of casual employment that makes it clear that a casual employee is someone who has no firm advanced commitment to continuing an indefinite work according to an agreed pattern of work. And by doing this and providing a pathway for universal casual conversion entitlement means casual employees now have more opportunity to convert to permanent employment. This just requires employers, except for small businesses, to offer full-time or part-time employment to eligible casuals after 12 months' employment unless there are reasonable grounds not to do so. Now, what we have done is provided that pathway for people to be able to convert their working behaviour based on their interests. We've worked with small business, we've worked with employees to be able to provide choices that seek what they want. But of course, we know full well that has been imposed every step of the way by the Australian Labor Party. Why? Because it empowers workers and it doesn't empower unions. In February 2021, Anthony Albanese and Labor voted against providing casuals with a more secure pathway to permanency and removing the $39 billion double-dipping liability on business. I was wrong, actually, Deputy Speaker, in my comments before about why Labor voted against these issues, because they thought that it would empower workers and not empower unions. It is because it would empower workers to be able to make their choices and make the decisions about their own employment arrangements. But the reason they voted against it wasn't because it didn't empower unions, it's because it didn't empower union bosses, who are their mates, who are the people just like superannuation funds and others whose terms they want to dictate and empower at the expense of average Australians.
The question